Ms. Robertson, your suggestion to us is that we throw in absolutely everything so that in some future case we will be sure to have some sort of distinction.
I think our test here is consistent with any ordinary principle of statutory construction, which is we don't want to suggest there are hard and fast rules here. And yes, we do
say
think—
yes. You can just say yes.
We do think it's important to rely on all the textual clues.
Well, what about the prior statute? Was that punitive too?
Yes, we do think that restitution under the VWPA was criminal punishment. The government took that position.
Well, then what do you have to say about Section 2 of the VWPA, which says explicitly the purpose of this is to help victims?
The reason that the government took the position when this question was litigated that the VWPA was a criminal punishment is because that statute uses similar language to the one at issue here. It does refer to restitution as a penalty. There was also plenty of statements within the legislative history there that Congress intended
legislative history. In the statute itself, Congress lamented that the criminal justice system had ignored the physical, psychological, and financial hardship of victims, found that the criminal justice system focused only on identifying and punishing offenders. As a consequence, victims had lost valuable property to the criminal. Congress enacted with that act with the stated purpose of ensuring that the federal government does all that is possible within limits of available resources to assist victims. If this turns on congressional intent, how much clearer could congressional intent be than that, right in the statute itself?
We would draw a line between whether Congress intends something to be punishment and the purposes that a particular punishment might serve. It's not unusual, for instance, for criminal fines to serve a compensatory purpose. By statute, most criminal fines are obligated to the Crime Victims Fund. So we do think that a punishment can serve a compensatory purpose, but there's still a threshold question of whether Congress intended to implement the measure as a punishment. And for purposes of
I thought the question was congressional intent. If Congress says our intent is to assist victims, isn't that open and shut then?
Well, we think the fact that Congress refers to restitution as a penalty is similar to saying restitution is punishment, and there's no plainer statement of intent than that from the text. But for purposes of this case, I think it is important that whatever questions might have existed about the VWPA when it was first enacted, the courts of appeals uniformly treated VWPA as criminal punishment. That's a consensus that this court observed in Kelly. Congress was legislating against that backdrop.
Maybe they were right, maybe they weren't. Maybe they, like possibly you, are worried about the consequences of saying that it's not penal. But then you have the VWPA followed by the MVRA, the mandatory victims, talks expressly about victims. Doesn't that show what Congress is getting at?
Again, we don't want to gainsay the important role that victims play in Congress's motivation here, but just as to the threshold question, we do think Congress's intent to implement criminal punishment is clear. And as to the consequences, there is a real consequence to treating restitution under the MVRA as a civil penalty, and that's the concerns that it would implicate the Seventh Amendment. We think that was the concern.